please rise?
Couldn't see it.
RailroadingRestvedt2-Conflict, case number 18-1643. Brad Meager for the state. The defendant is here out of custody, represented by Lisa Martinez. A couple things on the docket. First, the state is confirming for trial next week. I think we're primary at this point. Going out on Tuesday or Wednesday?
I think Thursday.
That's even better.
Last I heard.
Okay,
Thursday and Friday.
Okay, Thursday, Friday would be great for the state.
Well, we need to check with court administration because the last I heard was when I talked to court administration, it was Thursday because of some other things were going on.
And I was under the impression it was Monday.
It's for the week. It's for the week. That's when they're set for it. So we can have you go out and talk to court administration when we're done. But that was my understanding that we're looking at Thursday and Friday for this case.
So before we agree to that, will we be able to know?
Let's just go. We'll check with court administration right now.
Yeah.
Because it depends on other cases.
And then I provided counsel a copy of the state's proposed findings. You know, we have a couple days if the court needs me to change anything, I can. But this is a relatively quick turnaround.
Sure. So, Ms. Martinez, with regard to the findings, have you had a chance to look at them?
We are reviewing it right now, Your Honor. I apologize. We just got it before walking in. Okay. So, Your Honor, my client does have some concerns about the way 1.1 is listed. I believe it was on the record that Officer Dorff said that he was dispatched, and then Officer Huerta showed up to cover Officer Dorff.
So, with what's listed there, what's wrong with
So here it's listed that Officers Huerta and Dorff were dispatched, which would lead one to believe that they were both dispatched at the same time.
Well, I'll accept that because that was the testimony. They both indicated that they were dispatched.
Together.
We just let the record reflect that we object to that.
Well, the difference was when they got there, and it's that Huerta was first, and then Dorff came in behind him, but they both testified from the stand that they got the call from dispatch and they were dispatched to the scene. So I'll leave 1.1 the way it is. What about any other? I had a question on 1.2.
I don't have it in front of me. But
it says that the firefighters reported that during their contact, the person they had met was aggressive towards them. I didn't hear that.
Yeah. Okay.
I think they said that he was rude to them, but there was nothing about him being aggressive. Just let your attorney talk.
And of course the state, that's of course fine, and I would have no objection to the court changing that to the word rude.
Okay.
Your Honor, it says Huerta and Dorff could both smell wood burning smoke.
seeing it. It's just that they both smelled it.
I think the one officer said he saw, when he came around, he saw it through the tarp, yeah.
Yeah, so they're in 1.8.
Yes.
But they didn't see it from the other side.
Correct.
The conclusions of law 2.1, it says the court finds the officers had a legitimate emergency concern in ensuring the defendant's fire was out during a countywide bird ban. I just want to be sure that you're taking into consideration that it was a testimony of the officers that they did not sense any emergency.
Well, I'm just quoting the exception to the rule.
This is the exception. I agree. This is the exception. This is a legal conclusion. Whether they felt there was an emergency, like the fire was getting out of control at that instant, in that sense, and that's what I took that to mean when there wasn't an emergency. But actually, what I will do is I'll strike the first 3 words that the court finds, because it's not. I don't want to make it more confusing. So the officers had a legitimate emergency concern.
Okay.
Strike the same 3 words on 2.2.
Yeah, the court finds, in other words,
well,
you're striking those.
Yeah, well, the court finds that.
Yeah, okay.
And I'm going to just replace that with the word the facts.
That's I just got bit by the Court of Appeals on that. Sent one back. No, it's not. That's a finding of fact, not a conclusion of law, counsel. Oh, okay. Yeah, that's correct. I agree with counsel to strike there's a sentence in there on, was it 2.2? That the counsel, I see it from all. We've agreed to strike 3.2, the second sentence. I don't think that's necessary.
So,
where it says that
the defendant's what? Oh, sorry.
Did not cite the current RPC.
Yeah, that's not necessary.
But leave in where it says RPC 3.
Correct.
Wait.
RPC 3.7b expressly allows a waiver.
Yeah.
All right.
That's all, Your Honor.
Okay. So if you have one with those changes, I'll sign off on that.
All right, I can present those. I'll email those changes to counsel and present those to the court. Maybe they're on trial, calling a trial next week.
All right, I'll hang on to mine. I'll do that. All right, and then, so that leaves us with confirmation. We are set for Thursday and Friday on this matter. So, Ms. Martinez?
Your Honor.
Is the defense confirming that? Thursday, Friday?
Your Honor, my client would like to ask for a continuance due to some still pending discovery. As we mentioned in the motion, we are requesting that there be a thorough investigation regarding Brady material concerning Officer Huerta.
Well, let me ask that question. Is there any Brady material?
No, Your Honor, there's no Brady material at all regarding Officer Huerta. Our office does a check on that every time officers are called, and if there is Brady material, either from Centralia Police Department, Sheriff's Office, or any other police department that we deal with, we include those with the discovery.
Your Honor, it's known information that Mr. Restvedt's prior attorney had to relieve himself of this case because there was a conflict of interest because he represented Officer Huerta. So there's definitely reason to believe that there
Represented Officer Huerta in what?
in a criminal investigation.
against the officer?
Where the officer was a defendant. That is what Troy Resvedt's prior attorney had said, and that's why he had to relieve himself as attorney.
So that's news to me, first of all. Secondly, even if it's true, remember there has to be a finding in order for there to be a Brady violation. So if there's a finding somewhere that the officer was misstated the truth or lied under oath or anything like that, then there's a finding entered. And that occurs even in administrative hearings for employment or union problems, even a small criminal citation, anything like that. I'm not aware of any finding, and I'm not aware of anybody representing Officer Huerta in any other criminal violations.
Well, but the fact that you're unaware of it doesn't answer the question, right? So,
right.
Given, because this is a new issue, and that needs to be looked into, but my thought is, with the trial being Thursday, you should be able to get that information by tomorrow.
Easily.
And Your Honor, that's not the only thing. See, I didn't get more discovery until the 19th. And just as Mr. Meager said, he sent it out on the 17th. I received it the 19th. It's snail mail, it's not by email. And so with that new information, there are investigation procedures that we do want to hold. There's interviews that we would like to hold. Until getting the kind of more complete picture of this all, with still information trickling in here at the last moment, the defendant would like more time.
Okay, and this is referencing the other officers that came afterwards that we talked about yesterday? Is there some other discovery that you're talking about?
There are issues with fire, because we would like to talk to the man who was in the audio recording.
I don't know what you're talking about.
There's an audio recording from fire to dispatch, and there's a discrepancy between what the officers are saying that they received from dispatch. There's a discrepancy between what dispatch actually heard over that audio. I mean, it's plain as day that there was no, the person that was calling was not describing Troy Resvedt as aggressive. That there's a misunderstanding that has been spilled over into the officers then arriving to the house, feeling that they were going to show up to somebody who was aggressive. So we want to talk to fire.
That's why I changed that finding, because I agreed that there was not that aggressive statement. There was nothing to back that up.
Right, but we would need time to get those people subpoenaed, him being one, and then still finding out the origin of the call. Apparently there was a complaint that came in to fire. So, I mean, this is all part of a regular investigation. I don't know why we're acting like the origin of a call is not at issue. It's very much at issue. I mean, there's a whole abundance of rules around informers. There's things to be investigated here about the person who initially called fire that created that call from fire to dispatch that then led to dispatch sending officers out.
How does that relate to this gentleman swinging at the officer? They showed up, there was a fire. Okay. Who called it into the fire department earlier that day?
The defendant has a right.
Wait, don't interrupt.
Who called it into the fire department earlier that day has absolutely no relevance whatsoever. It's not even material to the assault which is charged. Yeah, and I mean, if counsel, she could have interviewed people during the last month. No request at all to interview anybody. We have the two officers under oath. She heard their entire testimony yesterday. You know, and so I'm not going to inject air into this thing. If he's out of custody, if she wants to enter a waiver and reset everything, go right ahead. And then she can do whatever public records request she wants. I will make inquiry into any Brady material that might be out there on any officer involved in this case. Provide that to counsel if there is any. And you know, I guess that's all I can say at this point.
So the current speedy trial expiration is November 21.
Right. I'm jammed the trials between now and then.
Right. So what are you asking for?
Well, we would like a continuance. We'd like to ask for at least a month with the number of people.
Well, that would require a waiver of speedy trial.
And we have no objection to that, Your Honor.
Okay, if there's a waiver of speedy trial, but it's going to have to be more than that because just scheduling wise then.
Current expiration on a new 90 track for today is going to be January 30th, Your Honor.
Right, you want to grab a waiver form?
Scheduled for January. She's good for January.
So is that what you want to do a waiver today for 90 days, starting today?
That's correct, Your Honor.
Okay, I'll make the new expiration January 30th. So trial, Mr. Meager, January 14th.
Let me grab a docket notice, Your Honor, and I'll write all that down. Last one. So, Ms. Martinez, January 14th, a good week for you?
That is good.
Okay.
All right, January 14th for a trial, January 10th for confirmation.
Now, given the allegations here about discovery problems, I'd like a discovery conference in front of the court, perhaps on January 3rd.
Well, let's do it before that.
Okay, the 20th?
Let's do it in December, yeah.
By December 20, Your Honor.
Your Honor, December 20th will not work for me if you were entertaining that date.
13th?
December 13th will work.
All right, December 13th.
Will Mr. Resvedt need to be here for that, Your Honor?
Yes, he does. December 13th, and that'll be at 3 o'clock.
And for clarification, January 14th, that's not the actual trial date.
It's the week of.
Any time during that week it
Yes.
would start.
Yes. And then let's also put in there, Mr. Meager, that I want the state to make the inquiry regarding Brady information, get that to council by next Friday, November 9th.
By the 9th, Your Honor?
Correct.
All right.
And then, since we've moved the trial, we need to set a time for presentation of these findings. Let's do that. Let's just say January 3rd on the calendar, because I'll be presiding then, assuming, and that's just because I want to make sure it happens.
Right.
If you're able to get them done, you should be able to get that redone and just submit it next party, and then we can strike that hearing.
Right.
I don't want to lose track of it.
Your Honor, on the findings, so you have your copy there?
Yes.
Great, I'll just make my notes.
You understand that you have a right to speedy trial within 90 days of the date of your arraignment?
Yes.
You understand by signing this waiver, you're giving that right up, and by the terms of this, you're agreeing that the matter can be heard anytime up until January 30th of next year?
Yes, I do.
Did you sign this voluntarily?
I sure did.
One more item, Your Honor. State sort of, well, let's just say had a sixth sense about this and thought there was going to be a request for continuance. So since there's no longer any time problems, I have an amended information. Adds account of the gross misdemeanor violation of a county ordinance burn ban. I asked to be allowed to amend the information to include that additional charge. Obviously, it doesn't add anything in terms of facts to the case. Court heard all that yesterday, so was counsel, so.
We acknowledge receipt of the information.
To do an arraignment on the amended information then?
Yes, Your Honor.
All right, Mr. Restvedt, to the amended information charging you on count 1 with assault in the 3rd degree, what is your plea?
Not guilty.
Count 2, resisting arrest, what is your plea?
Not guilty.
And count 3, violation of county resolution burn ban?
Not guilty.
All right, pleas are not guilty on the amended information. Okay, anything else, Mr. Meeker?
I think that's it. Thank you, Your Honor.